All right, today we are digging into a really important Canadian Supreme Court case, and it asks a pretty fundamental question. When you're under arrest, where exactly does your right to privacy end and police power begin? This is the story of R.V. Golden, a case that literally set the modern rules for one of the most invasive searches that police can possibly conduct. I mean, think about it. It's a question most of us hope we never, ever have to answer for real. We generally accept that, okay, a pat down for weapons makes sense. But what happens when that search goes further? How much further is just too far? This very question is right at the heart of the events that went down in a Toronto sandwich shop one winter afternoon. So our story starts on January 18th, 1997. Police in Toronto have set up a surveillance post. They're in an empty building, and their eyes are locked on a Subway sandwich shop across the street, in an area they knew was common for drug trafficking. An officer's watching all this unfold from about 70 feet away, using a telescope, and he later testifies that he sees two separate deals go down. He sees Ian Golden pass a white substance from his palm to other people in exchange for cash. So, convinced he's witnessing drug trafficking, the officer radios his takedown team and tells them to move in and make the arrest. Now, the arrest itself happens fast. Mr. Golden and two other people are taken into custody right there inside the restaurant. But what started as a pretty standard arrest is about to escalate, and fast, into a series of searches that become more and more invasive and way more controversial. The first step is exactly what you'd expect, right? An officer does a pat-down search of Mr. Golden, checks his pockets. And what do they find? Nothing. Absolutely nothing. No weapons, no drugs. Now, for a lot of arrests, that might have been the end of the search, but not this time. The arresting officer, he decides to conduct what the court documents later called a visual inspection. So he takes Mr. Golden to the landing of a stairwell that led down to the basement bathrooms. And there, the officer undoes Mr. Golden's pants, pulls them back, and sees a little piece of clear plastic wrap sticking out from between his buttocks. Well, when the officer tries to grab it, a struggle breaks out. After that struggle on the stairs, the officers move Mr. Golden back into the main part of the restaurant, which they've now cleared of any customers. They force him to bend over a table, and they pull his pants and his underwear all the way down, completely exposing him in front of several other officers and even a restaurant employee. And from there, the situation just gets even more degrading. Mr. Golden is clenching his muscles so the officers can't get the package. Amid all this chaos, he actually defecates by accident. An officer then puts on a pair of rubber dishwashing gloves, the kind they use for cleaning toilets, to try and remove the package while Mr. Golden is being held face down on the floor. Once they finally removed the package, it turned out to contain 10.1 grams of crack cocaine. But this case was never really just about the drugs. It became this huge legal challenge, pitting the actions of the police against one of the most fundamental rights guaranteed to every single Canadian. And this is the battleground, right here. Section 8 of the Charter. It's what protects every single one of us, our right to privacy and our dignity, from the state just coming in and overstepping. So the question for the courts was simple but absolutely monumental. Was the search of Ian Golden reasonable? And this really gets us to the core legal balancing act. On one side of the scale, you have the state's interest, which is totally legit, enforcing the law, grabbing evidence, keeping people safe. But on the other side, you have the individual's profound right to privacy, to bodily integrity, and to be free from procedures that the court would later call inherently humiliating and degrading. So, as you can imagine, this case made its way all the way up to the Supreme Court of Canada. And the justices there, they had to figure out this incredibly delicate balance, weighing the need for police to find evidence against the fundamental right to human dignity. And let me tell you, the answer was not simple, and it was not unanimous at all. The court was deeply divided, delivering a razor-thin 5-4 decision. And that split, well, it just goes to show you how complex and how contentious this whole issue really was, even for the top legal minds in the country. The majority, the 5 judges, they found that the search was a clear violation of Mr. Golden's Section 8 rights. They basically said the old common law rule, which just kind of allowed searches incidental to arrest, was way too vague. It just wasn't enough to protect people from such a serious invasion of privacy.
But the dissent, the other 4 judges, they argued that while, yeah, this specific search was done unreasonably, the legal framework we already had was good enough. They believed that creating brand new, sweeping rules, that's a job for Parliament, not for the courts.
In the end, though, the majority's decision had a massive impact. I mean, a huge one. It didn't just rule on what happened to one man. It created an entirely new legal framework for how and when police in Canada can conduct strip searches, a framework that's now known as the Golden Rules. And the foundation for these new rules is this really powerful statement. The court said, point blank, that strip searches are a profound violation of a person's dignity. And because of that, they can never be treated as just some routine, automatic thing that happens after an arrest. They have to be the exception, not the rule.
So here's the new framework the court laid out. Police can't just conduct a strip search because they arrested you. Nope. They need specific, reasonable grounds for the search itself. And the search has to have a valid purpose, like looking for weapons or preserving evidence for that specific crime. And maybe most importantly, how they do the search must be reasonable. That means it should be done in private at a police station unless there's some urgent reason not to. And it has to be done in a way that respects the person's dignity, health, and safety. So when the court applied these brand new rules back to Ian Golden's case, well, the violations became crystal clear. The decision to do the strip search was based on what the court basically called a hunch. There was no urgent need to do it right there in a sandwich shop, especially when the police station was just 2 minutes away. The way it was conducted, in public with dishwashing gloves, showed a flagrant disregard for his dignity. And all of that led to the conclusion that his charter rights were, without a doubt, violated.
The legacy of R.V. Golden is this set of rules, designed to protect the dignity of a person even when they're being arrested. But it leaves us with this big, lingering question that our society is still debating today. In that constant push and pull between security and liberty, have we drawn the line in the right place?